The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Thank you, Madam Clerk. Will the courtroom clerk please call the case?
This is Supreme Court case number CRA21-008. People of Guam, Plaintiff Appellee versus Wesen, aka Wesen, aka Wesen, Defendant Appellant. Appearing for the Defendant Appellant is Attorney James M. Maher. Appearing for the Plaintiff Appellee is Attorney Christine Santos Tenorio. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Maher reserves 7 minutes.
Thank you. Good morning, counsels. And Attorney Maher, you may begin.
Good morning, Chief Justice Carbolito, Justice Torres, and Justice Merriman. I will go down the arguments as I deem them of order of importance, although I realize the court may not agree with the importance I deem it for these arguments. The first argument is the consent defense instruction and the absence of that at trial. I submit that this was a very serious error on the part of the court and a part of the attorneys involved. There was evidence in the record of consent, specifically the defendant's testimony and the victim's testimony that the defendant was her boyfriend. So reasons that have not been adequately explained, and I'm not sure we'll ever know why, this instruction was simply not given. The government's position, I disagree with.
Well, what about the idea that force or coercion, which is a necessary element of all the counts other than charge one, and the defense of consent only goes to other than the charge one counts, right? I mean, you agree on that. It doesn't deal with charge one.
Yes, I do.
Okay.
I stated that in my brief.
Right. So when the definition of force or coercion, which appears to track the language of the statute, doesn't that by itself necessarily imply that there was not consent when you look at that definition?
It does imply that, but our position, or Mr. Wesen's position, is that the decision, the fact finding, requires that the jury make that determination. And I've referred to it in discussing this with other people as sort of an expeditious resolution of an inconvenient fact, and that is the absence of this jury instruction. I believe because the legislature has deemed this to be a law, a valid law, a defense that the criminally accused can avail themselves of, provided there's evidence in the record, the jury must address that. I don't think the court should address it by agreeing with the prosecutor's argument that because there's an inference that can be drawn, that it should be omitted. I think that's the function of the jury. And I think by not even bringing it to the jury's attention through an instruction, they would naturally conclude or infer that it wasn't important and it need not be addressed. Now, I agree with the prosecutor's premise that there is evidence. Sometimes it's very weak. Perhaps it's illogical. Perhaps it's kind of silly. But nonetheless, I believe the jury must make that determination. I don't agree with the proposition that we can inferentially remove the jury from the fact-finding process.
But if they found force or coercion, which presumably they did, doesn't that by necessity suggest there was no consent?
It does suggest that. However, they weren't put on notice by an instruction that they had to address the consent evidence. They could have very easily thought, well, okay, it's nothing. The court has not instructed us on it, so we need not reach and decide those facts. That's the fundamental problem here.
Is there a distinction that the consent defense is not described as a justification defense in the statute? I mean, in Gargarita, we have pointed out that the justification defense of self-defense there was specifically defined when all the definition of justification, the instruction was given. The instruction was given as to self-defense and force and coercion, but there was no tie-in. There we said that there needs to be an explanation as how the self-defense constitutes a justification and who has the respective burdens. Is there a distinction here that consent is described as an other defense, and the fact that, as Justice Torres points out, that the force and coercion definition was given, there it can be argued that there is a distinction in this case, and that the implication may be sufficient, that if there is force and coercion, then by implication, there is no consent.
Well, I know the government's position is there is a distinction. I don't see a distinction. And I once again, to me, it's a bit of a red herring in that I submit that no matter what we call it, a justification defense or an other defense, the court and the attorneys involved had a duty to see that this instruction was given, simply because these are facts that juries must deal with. That is their function. And it wasn't done.
Mr. Maher, you argue that there should be also an instruction that shifts the burden of proof back to the government to affirmatively show there was no consent. What is the basis for that
Yes.
argument?
Well, I
What
base
is-
that on, I'm sorry.
Go ahead.
Well, following the policy underlying Gargarita, they must negate that by proving beyond a reasonable doubt that there's no validity to it.
But in Gargarita, the statutory definition of justification defense within its scope, it includes self-defense. That's not how it's set out in the statute in reference to the consent defense. It is styled as an other defense, and that's why I'm asking, is there, number one, there is obviously a difference in the statute in terms of how it's laid out and whether or not there is any meaning to that as for us to determine. But as Justice Merriman points out, there's nothing in the statute that requires the government to disprove that the defendant here did not obtain the consent of the victim, or that the victim did not consent.
Okay, so there's no duty to prove that, to disprove the defendant's defense that it was consensual. If that's, I can see that I can see the statute does not state that or make that as a mandate for the jury and of course the government's case to provide that. I agree with that. But I'm still of the opinion that it had to be given. It still had to. The instruction on consent had to be given.
I know that's your opinion, but what is the basis of your opinion, I think, is what we're asking here. The basis for the obligation of the part of the government to disprove the self-defense, even if it proves each and every element of the crime as charged, is based on the statutory requirement as set out in the justification section of defenses in our criminal code.
You didn't cite any authority, Mr. Maher, for this point that the Chief Justice is bringing up. You cited no law that consent is an issue that requires a special jury instruction like self-defense because it's a justification defense. So we're trying to pin you down on what authority is available to support that proposition.
Well, okay. I will concede that I cited no authority for that proposition. But the proposition, the main proposition, is that the consent defense should have had an instruction. Now, what was contained in that instruction, we could obviously disagree on, or at least make arguments both ways, but it was completely absent. That is the concern that I have raised, that there was no instruction on consent. And I think the case I cited was the Root case, and a few U.S. Supreme Court opinions that, you know, the criminally accused is entitled to present a complete defense. And I submit that this was a serious error in that defendant's right. That's
Well,
what
even if we assume that you are correct in that part of your argument, that under People versus Root, that there is evidence of a consensual relationship, and where the juror can rationally, then it can be argued that there's a rational basis for the defendant's actions. And even if there is that evidence that you said, because of the testimony of the defendant saying that he never used the word consensual, never used the word consent, but there was a description of an arrangement. And so even with that, you didn't, at least I don't pick up from your brief, that how is the defendant's substantial rights affected if there was this force or coercion instruction with the corresponding definitions given. You just said that there was error, but I don't think your argument is that this is a fundamental error, but you needed to show how the defendant's substantial rights were affected.
well, the jury was never tasked with making a finding whether there was consent. That's the fundamental error.
Yeah, but what about the argument that since the government had the burden to show beyond a reasonable doubt that force or coercion, which is what he was charged with, was used in carrying out the sexual acts in this case, and the fact that the jury listened to the testimony of the victim, listened to the testimony of the defendant. The victim said, "No, I was afraid, if I didn't agree, that he would spank me, that there would be some force that would be used to carry this out." And from the verdict, it appears that the jury then believed the testimony of the victim.
And then the argument is and therefore the jury, that is, concluded that there could not be consent. That seems to be the argument by inference. But
Well, force
force
and coercion and consent don't seem to coexist. So, if force or coercion is proven beyond a reasonable doubt, as has been pointed out, lack of consent by necessity is also proven beyond a reasonable doubt. I mean, it seems that they can't coexist. But I think we should go on to the other arguments, Mr. Maher. I want to address the prior bad acts and the 413B evidence, and I also would like you to address the issue, because I think we have authority on it, of the reasonable doubt instruction on the age. I think those are to me, more troubling issues that I think I want you to address.
Well, the age is, as you can see from the brief, that was put toward the end because I deemed it of that importance. There was an instruction by the court, essentially, that the victim was a certain age, and that, of course, went to the first charge, count 1, which I think was an error. Okay. However, the government's position is, well, we introduced evidence and in the form of I believe it was a passport and we also elicited testimony from the victim. Now, of course, the victim, her testimony was very problematic because she went all over the place about her age at the time of trial, from which you could infer how old she was regarding the first charge, count 1. It's troubling that the court would do something like that, but I think the argument that the government made is the correct argument, and that is there was other evidence. I think it's a problem, though. Once again, we're getting back to jury instructions and what the impact of a jury instruction is, or the absence of one. We all have seen cases, I think this court has cited cases about the effect, the power of a jury instruction on a juror or jurors. So it's a hard calculus to make, but we can probably all agree that once the court instructs, it has a very profound influence on the jurors. And conversely, back to my first argument, the absence of one has a profound effect on the jurors.
Well, our case, People v. Hill, makes it clear that it's error for the court to specifically provide the victim's birth date in the jury instruction. The question is whether this error affected your client's substantial rights.
Right.
And so why do you believe it affected his substantial rights in this case?
Well, if I had to categorize the evidence, we have an error in the instruction. I think the government agrees with that. We have a witness. The entire case rose or fell on her testimony. And it was very, very poor testimony. It was quite ambiguous. It was contradictory, and it was all of that on material facts. The only, I think, saving grace for the government is the fact that they introduced a passport with a birth date in it. Now, weighing that, I would weigh on the side of caution and in favor, kind of a rule of lenity. I realize we're not talking about a statute, but the same concept, that if we're going to err, we should err on the side of the criminally accused. And I think that would affect his ability, back to my statement about the profound effect of a jury instruction. The jurors are naturally going to just say, well, it's a done deal. The judge told us this. The jury instructions go into the court, into the chambers for them to deliberate. They look at it, end of story.
So your argument is essentially contrary to like the Hill case, where there was no dispute or no challenge to the age. You're suggesting that here, because the varying testimony by the victim, that she was 20, she was 19, she was 18, that on cross-examination you raised age, or the trial counsel raised age as a matter that was in dispute, and therefore the judge should not have put it in, and that distinguishes it from Hill. That's essentially your argument.
Yes, and I think the trial counsel did a fairly effective job at that. It wasn't just a one-off affair. It went back and forth about her age, because I think the government realized it was a problem, and that was in my brief how I segued into that investigator's testimony in my harmless error analysis, or I should say wrongly admitted evidence, because the age then became, because of the cross-examination of the witness, I think the government knew we got a big problem here, and then they bring in the investigator to attempt to, in effect, rehabilitate this narrative that they've constructed that has fallen to pieces before their eyes because the victim can't keep her story straight. So I do think it mushroomed into a big issue. And because it was the first charge, count 1, the government obviously realized, this is a significant problem. And so I'd like to say you can't look at these issues in isolation, because they all spill into each other. And I think that's the example of the stating of the age through this erroneous instruction, and her testimony, and then the government responding with the last witness being this investigator, who essentially confirms her first statement that the first sexual act with Mr. Wesen occurred in Chalampalua, not in Kaiser Dededo, where she lived when she was 15. And that's the kind of error that is significant, because the jurors are hearing something that really it is, it's a huge effect on their determination how old this girl was when she first had sex with Mr. Wesen, and where she was. Because if she was in Chalampaluan, there's a pretty good argument that she was over 16. And that would, of course, as I think I referred to it, as an age-sensitive charge. That would certainly eviscerate or may destroy that argument the government had made regarding her age. So, now, as far as the 404B or 413, my position, I think, is fairly clear on that. Mr. Bischoff asked explicitly for notice of bad acts, whatever you want to call them, in advance of trial, and they simply ignored it. They just ignored the request. And of course, their argument is, oh, well, we gave him notice in our police reports, which are not a matter of record. And even if they were in the police reports, detailed, meeting their obligation as to some factual details, witnesses, and then some time to review these, even if all that occurred, they still didn't say what we're going to use. And Mr. Bischoff said, please identify what you intend to use, and they just ignored it.
But did he file a motion in limine? I didn't. Yeah, he didn't raise the issue, under 413. And we've held in the past that if you fail to address an issue, we won't address it for the first instance on appeal. So at least on the 404B objection, there was no objection lodged at trial on the 404B.
No, there was none. That's correct. I mean, he asked for 404B evidence, and then when it was introduced, or now the government's saying it wasn't 404B, he didn't object to it. That's true. I can't deny that. But once again, I think this illustrates how collectively the process that Mr. Wesen had was significantly flawed. We have instruction errors. We have the omission of, evidence of bad acts, whatever you want to call it. We have the court not doing any balancing act under 403. We have the court not giving any limiting instructions, as this court has told the lower courts to conduct when this kind of evidence comes in. So we have collectively a pretty impaired process. And
the government argues that while they may not have provided the notice of use at trial under 413, actual notice was provided by virtue, I guess, of the discovery. And you argue that the discovery isn't a matter of record, and so it's unclear whether or not that what was provided in discovery actually gives notice that would be expected under the rule. Is this something that we should think about asking for?
yes. Yes, I believe so. I mean, I don't think Mr. Tenorio is lying or trying to fool anybody.
And if we ask for it and it ends up that information was provided in discovery, does that affect our analysis in terms of whether your client's substantial rights were affected?
We'd have to see what they told them. Once again, this court's held, I forget the case, I think it was, I think I've written it down, that to meet your obligation, you have to, I think it's tight now, you have to provide enough details surrounding the incident, names of witnesses, and of course, time for the defense to analyze it. We really don't know. That's the reason I made reference to matters of record. if we had these police reports or these investigative reports, whatever they are, we could then evaluate, well, do they meet the standards of a disclosure? But really, the problem is because of the sheer number that were alleged, 319 to 400 and something based on the testimony of sexual acts. I mean, that's a lot of acts, and we would have to at least ask, well, are you going to reduce the number? You have 6 charges. Of these 400 odd acts, which ones apply to these specific counts? I mean, once again, we're operating in a vacuum. We just don't know what these reports say. And we also, of course, if the reports don't reflect the number that seemed to be what the victim testified to, that would also, of course, be a form of impeachment. We just don't know. I guess that's what it comes down to. They should have been produced. There should have been a response to Mr. Bischoff's request for notice. They just ignored it, and they sprung it all at trial. That really affects people's, when you're in a trial, there are a lot of moving parts, things are going on, you get distracted, and to dump something on somebody at trial is, you might as well not even give it to them, because they're probably not going to have time to evaluate it. And out of an abundance of caution, not knowing the angles or the implications of the use of the evidence, a lot of people will say, I'm not even going to take that risk. I'm not even going to take this information the government just threw on my desk, because I don't know how it might backfire on me. And that's where we get into this ongoing problem of Mr. Wesen not being able to confront the evidence. He testifies on Fifth Amendment right to speak, confront evidence in the Sixth Amendment. And the government's position is we will eviscerate that by this expeditious inference drawing based on a factual finding made by a jury. So we have this process going on all the time where they're just cutting back on his ability to defend himself by either restricting the evidence the jury hears, or the instructions the jury receives, or instructions that affirmatively state an element that the government has the burden of proving. So it's.
Mr. Maher, you're into your rebuttal time, so I just.
Oh, that's right. Okay.
If you want to reserve your remaining time.
Yeah, I think I have about 3.5 minutes now.
All right, thank you. So, Assistant Attorney General Christine Tenorio, you are recognized.
Good morning, Chief Justice Carbolito, Justice Torres, Justice Merriman, and may it please the court. This is a case where the defendant, Wesen, sexually assaulted his essentially stepdaughter for a period of over 2 years between 2015 and 2017. These acts occurred from when she was below the age of consent to when she was above the age of consent. Hence why the government charged the incidents the way that we did. Notice was given to the defendant via the declaration, via the grand jury transcript, and via the indictment as to what particular counts were covering particular periods of time. So I'm going to turn to the first issue, which is the requirement of a jury instruction on the defense of consent. The people's position is that the burden to prove force or coercion beyond a reasonable doubt, any evidence going to that element that was presented necessarily requires a finding of lack of consent. As this court has noted in People v. Tenorio, there is no consent if the defendant uses force or coercion. Therefore, there was.
Tenorio, is that necessarily true in every case? Couldn't a victim consent to an abusive type of sexual relationship?
Assent is not the same as consent, would be my response. So in People v. Tenorio, the court did go over through elements of force or coercion is not limited, but can include different circumstances. In this case, the charges that went to that defense were every charge on every count, but count 1 of charge 1. And there was evidence presented on the force or coercion element, and the people repeatedly told the jury that the people had the burden to prove beyond a reasonable doubt force or coercion. And so when you look at the force or coercion element, I do want to say that our statute is modeled after Michigan. In Michigan, in the case law that I've cited to the court, Michigan states that there is no separate finding of an element of lack of consent. That's not an additional element to be proven, and that force or coercion necessarily proves that. And because we got our statute from Michigan, then that makes sense to follow that that ruling is, and the rationale is that the focus is supposed to be on the defendant's conduct of force or coercion and not necessarily on the victim's conduct of her or his lack of consent. And
what about the argument, Michigan, you may very well, the case law say what you have represented, but we have Gargarita in our jurisdiction. And in that case, we said that there must be a tie-in reference to the defense. In that particular case, there was the justification instruction, there was self-defense, there was force or coercion, but we said that was not enough, that there needs to be a clarification so the jury doesn't have to guess how all this ties in and who has the respective, first of all, how self-defense works, and then who has the burden of proof to disprove that the defendant acted in self-defense. And so here you're asking us then to approve that you can glean that the consent of the victim was obtained by implication. And because if the government proves the force or coercion element, that's all that's necessary. That means that there is no consent. But in this particular case, there was evidence of a consensual relationship. And that is that, according to the defendant, that the mother agreed for the daughter to have this type of relationship. And so with that evidence that's on the record, and with the instruction that so long as we prove force or coercion, really consent doesn't matter. And so I'm having a little difficulty in reference in our jurisdiction, maybe in terms of other jurisdictions where there is not this case that specifically says that the jury can't guess or should not be put into position that they need to guess how the various defenses work. And here the defendant is arguing that there was no consent instruction, and just giving the instruction of the definition of force or coercion is not sufficient.
so I do think that this case is distinguished from Gargarita because consent is not a justification defense. Why I think that's important, it's an important distinction, is that in Gargarita, this court ruled that the government has the burden of disproving the justification defense. This is not the case. The consent as a defense, the only place consent is found is not in the justification defenses, it's in the chapter before that. So I think that's different because that means that the government does not have to disprove the defense of consent. So I think that that's where it's distinguished from Gargarita. As far as the court's concern about
but let me just interrupt for just 1 second. But I thought the argument is that if we prove force or coercion, we are disproving consent. I thought that was your argument. And so now you're saying that because the jury and the statutory scheme doesn't specify consent as a justification defense, by definition means that we that the government doesn't have to disprove consent.
So my position is still that when we prove force or coercion, we are proving a lack of consent because the evidence would be the same. The distinction is with the burden and what the burden becomes as far as what is told to the jury. And that being said, I think that's why it's important to put this in the context of what the standard of error or standard of review is here, because under a plain error standard review, the evidence, if it does not affect the verdict, then this whole conversation really isn't an issue, because yes, while a complete set of jury instructions is preferable, all the case law that I have researched on this issue of consent is, as long as it's very clear to the jury that there was no consent and that the people relied on a lack of consent, then it does then the verdict wouldn't have been different. And that's why I put in this case a lack of a jury instruction if the court finds this error under People v. Root. Lack of jury instruction wouldn't amount to a reversal because it was very clear, and throughout the prosecutor's closing arguments, he kept saying this is a case of forced sex. Their story is that it was a consensual, but we believe it's forced. And at the end of the day, the reason why this didn't affect the verdict is because it is clear that the jury took that into consideration and weighed credibility in the favor of the victim in this case, because Mr. Wesen testified. Mr. Wesen testified that it was consensual, and they rejected that assertion for the 5 counts.
But Mr. Maher's argument is, had the instruction been given, that there was a rational basis that the jury could have determined that there was a consensual relationship. Had the jury been told that if the victim, other than, as you say, the first charge, count 1, consented to this the sexual arrangement here, and had they been given an instruction that specifically said that that you must acquit the defendant, and that there is a rational basis that giving this instruction could have affected the verdict. I thought that was the argument. And because that there is no instruction, then they couldn't make that tie-in.
That's where I disagree. I know that's Mr. Maher's opinion, but I think that the evidence and reviewing the evidence shows that it would not have affected the verdict, even if that instruction was given. Also, I would like to point out the evidence proved that she was pregnant with this child. So the jury already had the evidence that there was a sexual intercourse because that she was pregnant, and because Mr. Wesen admitted that it was his son. So I just don't think a jury instruction under a plain error standard of review would have affected or changed the verdict necessarily. Although I do understand the argument, I don't think that the verdict would have been different.
Had there been an objection in the instruction that the defense counsel had asked for the instruction was not given, would the government's position change in reference to whether or not there was reversible error in this case?
I think that the government would not have objected to an instruction had it been asked for. But the problem with that is that even under People v. Regis, this court has acknowledged that there's no definition of what sexual consent looks like. And so then the argument would have been a different argument, which is what consent instruction would be given. But I think that if they asked for it below, we wouldn't have objected to it. But I think that the issue here is that all parties believe that it was clear, and that's why under the prong, whether it was clear or obvious under the law, I think that the error was not clear or obvious under the law, because this court, in all the cases of criminal sexual conduct based on force or coercion, has never required a separate element, a separate jury instruction of consent, even given the Root has been on the books for over a decade now. Nobody has said that it is required. So this was not clear or obvious under the law. Turning to the next point about the testimony regarding the other acts. So as I briefed, essentially the issue is that nobody was really considering the testimony of the other acts as other acts. I say that because while Mr. Bischoff filed his notice of 404B, he never filed a motion in limine to exclude. And it was always clear by the charging document, and under, I think, People v. Felder, this court says whether someone has notice, you go to the other court records, the accompanying magistrate's complaint with the charging documents. And in this case, it was always said in the declaration that this had occurred multiple times a week. And I do have that discovery if the court wants it. That's not normally a record on appeal, but I'm making that representation as an officer of the court it was always in discovery and in the police report and then in the complaint. So the issue here, it becomes a charging issue because when someone has been abused for such a long period of time, we have to go with one act per period of time, as long as the victim testifies to one act. So why this context is important is because in this case, no one was viewing I think that the view was that the other acts were direct evidence of the actual charged act. And that's why my first argument is that the testimony is actually admissible, not under, you don't even get to the Rule 404B or 413 analysis. We view this as direct evidence of the charged act, intrinsic, and it's intrinsic to the charged act because the victim testimony would have had to be sanitized if we rule the other way. That being said, she's always said, whatever she said, 1 to 4 times a week, 2 to 4 times a week, that period of time. And so if you take that context out and we forced her to just say only one time, then that's when you have credibility problems because then, jurors wonder, well, how is this only an isolated act? So the view is that this is direct evidence to corroborate the charged act. And so because of that, he was given notice by the discovery, which is why I'm going to keep pounding on that because he did have notice, which was why no one objected. I did cite a case from West Virginia where other courts say as when a victim can only recall a specificity to particular acts, even though so many other acts occurred during a period of time, those courts let that in as context of the one act that was charged. In this particular case, the prosecutor did elicit one detailed act per location. And there's a footnote where I actually reviewed all the charges and synthesized what locations and what time periods go to each charge and count. So because the prosecutor elicited specific details of one particular act per location, all the other acts were direct evidence of that act. So in that sense, it was inextricably intertwined. So like I said, her testimony was the most natural way of bringing it out. Mr. Maher says, this amounts to 400 some acts, but I redid the calculation in the footnote and I put it there because while there was a dispute in testimony, and it is correct that she initially said 3 years. She was at Challen in Kaiser Dededo, and then she changed it to 3 months. She clarified on redirect that it was 3 months, and that's the reason why that's important is because all the acts that go to uncharged acts that were not were only for a 3-month period of time when she was living in Kaiser, and why that matters is because then it couldn't have affected the verdict as to that particular act because the prosecutor, as in Glenn Santis, which that opinion just came out, that those acts were mentioned in passing. All she said was it happened this many times a week at this location. And then in closing, the prosecutor said, she testified this many, but you only have to be unanimous as to one. And that's it, he moved on. So direct evidence. If your honors don't believe that it's direct evidence of the actual charged act, I do think that it is admissible under Rule 413. Now, again, nobody brought this up below, and Mr. Maher didn't bring this up in his initial brief, but I think analysis is important because, again, I think this proves why nobody was objecting to it below, was because they were other sex acts that were part and parcel of the charged sex acts as far as the testimony goes. So if we analyze that under Rule 413, so I did actually have
the trial court made no findings at all regarding the analysis in this case, right? I mean, and we made it clear that they have a duty to ensure that these factual findings are made, even when the parties have stipulated to the testimony.
That's correct, Your Honor. That conclusion was recently made in People v. Santos, but before the court has said that you need to make a searching inquiry, but the issue was that nobody had brought it up below. So essentially, no one objected to this testimony, which under People v. Glenn Santos, this court actually recently analyzed it under plain error. I do want to say that about standard review. I actually analyzed everything under harmless error because I was viewing this as an evidentiary ruling about admissibility of evidence, which this court has repeatedly said falls under an abuse of discretion standard, and the reversal would only be required if the error was not harmless. But under both standards, if we were to consider this, again, nobody brought it up. And I think that was the issue in Glenn Santos as well, is that it wasn't a ruling to be made because the parties had stipulated. Here, there was no ruling to be made because nobody objected to the testimony because everyone thought it was direct evidence of the actual charged act. So that being said, there was no searching inquiry, but if this court reviews that de novo, so this court has never ruled that Rule 413 should be reviewed de novo, only Rule 404. But if this court reviews de novo and takes the factors, the Chanel factors into consideration and the 403 balancing, it's very clear that any testimony, the brief testimony of this happened 1 to 3 times or 1 to 4 times a week, that testimony satisfies the Chanel factors and therefore testimony of it was admissible. And the rationale for Rule 413 and notice, because again, everyone had noticed that this was going to be the testimony, is to ensure that the defendant is not surprised by these acts. So while Mr. Maher keeps using the phrase sprung on him at trial, I think that the charging documents are very clear that the time periods in question, and that there was no other acts other than those contained in the initial discovery and police report that were going to be introduced. We were just going to focus on the time periods here in question. So while there was no searching inquiry, again, under People v. Santos, this court has ruled a failure to conduct the searching inquiry. While that is error, we look to whether that error affected the defendant's substantial rights. It's the people's position his substantial rights were not affected in this case because he was able to take the stand and defend against this conduct. Of course, his defense was that the sex didn't start until after some of the charged time periods, but he always had that evidence in possession. So he always had that evidence to try to, so in case he needed to rebut it. His general defense was that it was consensual and that it happened later than she said it did. So if the court does not find that this, because under People v. Titano, this court declined to do a 413 analysis and instead proceeded under 404B for sex acts, I did cite the jurisdictions that do have adopted 413 have also ruled a similar testimony admissible under the opportunity for opportunity, intent, plan, and absence of mistake. So I did put out the Hinton factors, and under the Hinton factors, again, the brief testimony about 1 to 3 or 1 to 4 times a week would satisfy admissibility of those acts. Again, Written notice is not required under any of these statutes. It's not in the statute that written notice is required, but the defendant did have actual notice. His counsel could have brought a motion in limine, but he did not. And the test under fourth rebalancing is whether there's really unfair prejudice. Nothing, I think the most prejudicial evidence in this case was that she was pregnant with his child and that he admitted to impregnating her. And so any testimony about 1 to 4 times a week, I think it was less prejudicial than them actually seeing that she birthed his son. Going next to, we didn't get to talk about it, so I do want to talk about the variance issue. So there was no violation of due process under the 6th Amendment when the victim testified about the other acts. So this is what other courts call this is generic testimony. When a victim testifies for what she has been experiencing over a period of time, and those acts are not all necessarily charged. As long as the defendant has actual notice and the verdict was unanimous, there could be no possible disagreement about what act was in question, then there is no 6th Amendment violation. And again, in this case, the prosecutor said she testified in detail to 1 act per location. You just have to be unanimous to 1 act. With regard to the actual material variance issue, so again, there was no material variance because there was no difference in proof at trial and what was charged in the indictment. The time periods stayed the same, the charges stayed the same. And so looking at the material evidence factors, this court will review whether there's a sufficiency of the evidence of each count of each act. And again, the people concede that there was a dispute over her age and there was dispute over consent, but again, the jury resolved those disputes against the defendant, and they were able to view him on the stand in his testimony and then view her on the stand, and they did find in favor.
But I think the age issue is a little bit more difficult than the force of coercion versus.
Right. So I will get to the age as the element of the crime.
In the instruction.
Right. So I will get to that. I'm almost done with this particular argument. So finally, generic testimony about acts that have happened to a victim that are not necessarily charged does not infringe on the defendant's right to unanimous jury, as other courts have found, as long as the victim can specifically explain the kind of act that happened, the number of acts, and the alleged time period. That is sufficient notice of the law, and there's no violation. Going to your Honor's question about the age. So I do concede that under People v. Hill, this court said putting the date of birth in the jury instruction is erroneous. And so that is what happened here. It is erroneous because that's what your Honors had ruled. But I do want to say that the only way it ends up being in the jury instruction is that we actually have to put the date of birth in the charging document for notice issues. So I think that in this process, this is a good signal to us that even though it's in the charging document, we have to remove it, because it's not that the prosecutors are trying to say that the court said that this is her date of birth. It's just a matter of removing it for notice issue. So I do note that it was put there, but here the jury instruction said.
Let me just I just like to clarify that last statement. I mean, the issue we have is the jury instruction, not the indictment.
Right.
The
Understood.
jury instruction is specified that the victim's age in this particular case, and we've said that if age is an essential element of the crime that's charged, then the government has the burden to prove beyond a reasonable doubt that essential element. So putting it in the instruction takes that away.
Understood, Your Honor. I'm just giving context as to why this keeps occurring, which I'm going to make sure it does not occur anymore. So that being said, the jurors were instructed that they have to find the elements of each, the elements of the crime beyond a reasonable doubt. Right after it says whose date of OW, whose date of birth is this, it says a minor, at least 14, but less than 16. So I think that it was clear though to the jury that the people had to prove that element, and the date of birth was disputed. It was disputed. They heard all the cross-examination on it, and both prosecution and defense counsel during closing arguments really harped on that element of the crime. So while I do see the problem where it looks like a jury can say, oh, well, the court said that this is her date of birth, so we're going to find that. I don't think that occurred in this case because there was such a huge issue about what her date of birth was, and that both parties, the parties resolved it in favor of the victim because her passport says her date of birth. And I know there was a lot of discussion about, well, where she got the passport. They don't really ask you, or the proof that you need to prove your date of birth to get your passport. But that was resolved in favor of the victim. And I don't think it's because her date of birth was listed in the jury instruction, because they were, the prosecutor said, we have to prove to you that this is her date of birth. These are all the days that this is all the evidence that we used to prove it. Even if this is like the Hill case, where even if it was erroneous, the test is whether it will only be reversed. The test is plain error, and it will only be reversed if the outcome would have been different. And I think because the focus was on the evidence, there was a large portion focused on her evidence. This is not like Hill, where it was undisputed where her age was. This was a huge dispute, that the effect wouldn't have been different.
But there are jurisdictions like Washington State where inserting the age is a per se error and is a reversible error. And in jurisdictions, I note that counsels did not cite authority from other jurisdictions, neither the defense counsel or the prosecution. And in jurisdictions where they say it's not per se, there was very little conflict in the testimony in reference to the age of the victim, and therefore it was decided that there was not the substantial rights that were affected. That's not the case here. Even if we were to follow jurisdictions that say it's not per se error to include the victim's date of birth in the jury instruction, where it's an essential element of the crime. This was vigorously contested in this trial. I mean, the defense counsel made a big deal that during this period of time when the acts were committed, that she was not she was not greater than 14 or less than 16 years of age. So that was a issue, a main issue in as far as the first charge, count one, and the fact that the instruction specified the date of birth, is argued, took that away from the jury to decide.
So I understand the argument, and that's why I just keep conceding that it was erroneous. But as far as per se reversal when it's disputed, I think that only goes to the count one where she was between 14 to 16. So that would only affect one of the 6 counts. So if your honors, again, reverse on that basis, it would be for that particular count. But the reason we wouldn't affect the other counts is because by anybody's calculation, because I think the dispute was over a year. It was a 1-year difference, what was the dispute? Any dispute as to her age within that 1-year difference didn't affect the other 5 counts. That included the counts where he actually impregnated her. So I do understand the court's concern. And that would only affect count 1. I am out of time, so I didn't get to the last issue, but it's really simple. Rebuttal testimony was admissible under prior consistent statement exception.
Thank you. And you can submit your briefs on that issue. Thank you,
Thank you.
Mr. Attorney Maher, I think you still have
3.5 minutes, I think, CJ.
About
All
3.5.
Okay, well, you may proceed.
Okay, thank you, Mr. Justice. The government's position, I'm quoting, I hope accurately, if we prove force and coercion, we are proving lack of consent. Well, we don't know that because the jury was not allowed to make that finding. The jury was not instructed, you must make a finding on this issue. So once again, we're back to the government inferring, which is very, very dangerous to take away the right to put on a defense and then to have it essentially nullified because one logical element disproves the other. I don't think that is what this is about. I think it's a nullification of the statute itself. What I'm also troubled about is the defendant has the 5th, the 6th, and the 14th Amendment, specifically if the evidence is turned over, I don't submit it was, to confront that evidence under the 6th and to present defense to it. What we have here is sort of a conditional 5th, 6th, and 14th Amendment. If we find certain things, then everything you put on, your testimony on the stand, your cross-examination, that all loses its legal effect. That's essentially what the government is arguing here. We're going to do a post hoc analysis, but in the meantime, we'll allow you conditionally to put on a case. That is very, very troubling. And the government is also asking this court essentially to sort of, I guess it would be a separation of powers issue. Please ignore this statute. There's nothing to see here. Now, it might be cumbersome. It might be a little lengthier than that everyone likes, but let the jury make the decision. I don't see why there's a problem with that. I just think that this whole trend towards this kind of analysis is very disturbing. And I think it goes to this incremental destruction of constitutional rights, specifically for the criminally accused. That's what we're looking at. Now, the government also says the first charge, that's a statutory rape charge. The age instruction was an error. And essentially that's the only error here. No. We had the inadmissible evidence of the special investigator. The special investigator came on and then essentially gave away the game by saying, well, the first charge, the first sexual act occurred in this 3rd village that the defendant or the victim lived in. Okay. But that was another attempt to rehabilitate their weak case. And that went to the first charge, first count. First charge, first count. Now, I disagree with the government's position that they proved 1 act per village for this reason. Very vague testimony about the individual acts. The villages, as we know, they changed as the testimony changed, as I just alluded to. But what I posit this question to the government. Okay, let's assume what you say is true and that's in the record. What happens when you change the chronology of villages? Does the act that you testified initially to in Kaiser, now because you've changed it to Chalampuan, apply to Chalampuan? Does Chalampuan apply to Kaiser? Does Kaiser apply to Mighty? So you can see the problem with the government's argument. Yes, there was vague testimony about various acts in various villages, but then they changed the villages. And that goes back to our concern about pretrial notice of acts that you're going to use to prove your case. Because by their own admission, they changed the order of the acts. Mr. Wesen had no opportunity to confront this because it was a moving target. That's the problem here, among many. So that I rest on that. Thank you.
Thank you, Mr. Maher. Thank you, counsels, for your arguments. And the court will, of course, examine the record and the arguments you have advanced today. And we thank you for your time, and we will take the matter under advisement, and the court stands adjourned. Thank you.
Thank you.
Thank you.
Thank you.